Okay, inshallah, we'll get started. Bismillah. Again, assalamu alaikum.
You're live.
Thank you. I'm also live on Zoom, so for the people that are on Zoom, if you could please mute yourself. Thank you. First, I want to thank the Atlanta Masjid as well as Imam Suleiman for inviting me to do this Taleem on trust and wills. It's a very important topic. So thank you so much for inviting me to speak on this important topic. Inshallah, you find it insightful, official, and that you take some information away and learn something, and also do some homework and some research, inshallah. Okay. Without further ado, I want to first start just by saying that as Muslims, we already know that our wealth is a trust from Allah, right? And we also know that we can't take it with us. And so by having an estate plan, whether that's a trust or will, and I'll get to the differences between the both, by having that set up before we pass away, it ensures justice, it ensures mercy and accountability, right? And it's important to note that when you do not have a plan, and I think we live in America, when you do not have a plan, this is not a Muslim country. We do not live outside of within ourselves. Islamic law is not what governs where we stay. So if you do not do planning yourself, the state you live in, so if you live in Georgia, Georgia has a plan for your assets. It has a plan for your family. If you live in Texas, where I'm also licensed, it has a plan for your assets. That state has a plan for your family. And let me back up a little bit because I did not introduce myself, so forgive me for that. But my name is India Ali. I'm an attorney here in Georgia, I'm licensed here as well as Texas. I've been practicing law for the past, since 2014, so that's 11 years. I established the law office of India Y. Ali in the summer of 2019, so I just celebrated, alhamdulillah, 6 years of entrepreneurship. I shifted gears and started focusing my practice, specifically focusing my practice on trust and estate planning in 2021 after the death of my mom. And so I made it my mission, and my husband Ishmael, he's not here, but we made it our mission, he also works within the firm, to make sure we gather as much information as possible about estate planning and share that, one, with our family, but also the community, because it's so important. Okay. But again, going back to where I started, our wealth is a trust from Allah. Planning ensures justice, accountability, and mercy. And if you do not plan, without planning, the state you live in is going to dictate what happens to your stuff, how it goes, who it goes to, when it goes, how much goes. So it's incumbent upon us, one, as Muslims, because the Quran obligates us to do it anyway. But it's also important to do planning, because if you do not, the state you live in will do the planning for you. Want to shift to the Quranic guidance on estate planning. I'm not going to go into detail, but if you have notes, you can take it down and you can look at the surahs when you have the time. But in Surah Al-Baqarah, verse 180, that's where we are commanded to do a will. Before we pass away, you are to do a will. And I use the term will loosely, and I'll explain later why I say that. But essentially, in that verse, in that ayah, in that verse, that's where Allah commands us to do estate planning. Okay? And then later, in Surah An-Nisa, verses 11, 12, and 176, that's where Allah lays out the inheritance guidelines, the inheritance laws of how your assets are to be divided amongst family. So again, we know, based on what the Quran says, estate planning is a commandment from Allah. And then we know, based on what the Quran says, our assets, our estate plan, what we have is to be divided in a certain way, because we're Muslim, with our Muslim family and or charity or non-Muslim relatives and how that's to be divided, right? It's clear guidance on that. Key reasons to plan ahead, and I touched some of them already. Again, we non-Islamic, I'm gonna hold this. We live under non-Islamic legal system, right? When you plan ahead, it prevents conflict. I've seen it so many times. People pass away, Muslim or non-Muslim. They don't do a plan, and now the family's arguing on who should get what, because I had this conversation with mom, and then they had this conversation with mom, and now we're at odds about how we should get it, when we should get it, who should get what, because there was no clear guidance. There was no clear instructions left by the parent. It prevents confusion, because when you do an estate plan, the family knows what your stuff is. I've seen plenty of people pass away and their family comes through to my office. They have not a clue what the person had. Now they're doing a scavenger hunt and they're asking me, can I help them find the stuff? I don't know where the person's stuff is. Okay? So it's incumbent upon us to make sure our family knows what we have, right? You have to take stock of what you have, take an inventory of what you have to prevent that confusion. Also, when you have an estate plan, it helps to prevent delays, right? I'll get into, again, the nuances and the differences between a will and a trust. But again, just in my professional experience and my own personal experience of going through a probate court process, seeing the time delay of when somebody passed away to when an heir actually got their inheritance, that can take 2 to 5 years, right? On a good note, it could take a year, but that's still a delay. So it's important when you have a plan in place, you can prevent potential delays. Lastly, and actually probably the most important, you're protecting your family and you're protecting your acronym. Okay? So again, steps you can take. Take stock of your assets. What is it that you have? What is an asset? And at some point, I'm going to want this to be interactive too. So an asset, do you have a home? Do you own real estate? And even if it has a mortgage, that's still an asset. Do you have life insurance? That's an asset. Do you have a 401k, an IRA, any other retirement plan? That's an asset. Do you own a business, a corporation, an LLC, a partnership? That's an asset. Do you own art that has appraised value? That's an asset. Do you have money underneath the mattress? That's an asset. Money in the bank, of course, that's an asset. So anything that has tangible value, that if in the open market, I can exchange it for something or I can sell it, that is an asset. There's also intangible assets, things that are inherently special or important to you. Your Quran is an asset, right? Ladies, we might have, our hijabs, our scarves, and, our clothing that we may want to leave to a specific person, our jewelry that we may want to leave to specific people. Those are assets. So really taking stock of what is it that you have. And if you're confused about what an asset is, please ask the question. So is this an asset? Another way to think about it, will my family fight over this thing? If the answer is yes, it's an asset. And you will be so surprised what people fight over. People fight over, I want that necklace. And so thinking about those things that are important to you, that also may be important to people. When people pass away, people grieve differently. And so it could be the littlest thing that people want to gravitate toward or hold on to because it's sentimental because the person passed away now. Now I want to fight for that thing now. But again, key reasons to plan ahead is having that conversation in advance with your family. You also need to take stock of your debt. Part of being Muslim is having an estate plan, but also making sure your debts are taken care of. That should not be your family's responsibility at all. That should not be the community's responsibility at all. Your debts are your responsibility, so making sure you know what those are, that your family knows what those are, and that you have a plan to take care of those debts. Also take stock of your heirs. Who are your heirs? If you're married, your spouse is an heir. If you have children, they're heirs. Parents are heirs. Siblings are heirs. Nieces and nephews potentially are heirs. So understanding who your heirs are. Especially important if you have a blended family. And I say that because if you have a blended family, and I have a blended family, so that's why it came to mind. My husband and I share 2 minor children. The rest of his children are adults. They're not my blood children, but he needs to make sure he has estate planning in place for his children that are not my children, right? I gave you all some surahs and ayats to look at, but learn about your Islamic obligations. If you're Muslim, you should know, again, you're obligated to do estate planning. The next step, obviously, is making sure once you know those things, making sure you do an estate plan, whether that's a trust or a will. Making sure you do that, and I'll explain, again, the differences between the both. While you're going through that process, if you have questions, get advice from a scholar, whether that be the imam, whether that be an estate planning attorney like myself. Make sure you're getting advice if you have questions. And always lead with dua, always making sure that you're having a family conversation. One of the things I always say when I'm talking about estate planning, one of the biggest mistakes people do is they do an estate plan, but the family has no idea they did it. So another thing to think about, you can have an estate plan, but if your family doesn't know where it is, it's as if you did not have one. So we go back to Georgia has a plan for your stuff. Because if your family can't find it, they have to go with what the law says in the state. Does all that make sense? Okay, inshallah. Any questions so far? Okay, alhamdulillah. Okay, so normally during any conversation I have with a potential client, or I'm doing a seminar or webinar, we use an acronym in my practice, in my firm. The acronym is FAITH. And I hope you guys write this down. It's pretty, it's helpful when you're digesting, I think, the conversation around estate planning. But FAITH, F-A-I-T-H. The F in FAITH is for your family dynamics. And going back to family dynamics, using myself as an example, I'm married. I have a blended family. I have 2 minor children. My father is still living. I have an older brother, a younger brother, and a teenage niece as well. And of course my husband. So those are my immediate family dynamics. So understanding what those are, because that's where you're going to be looking to when you're considering the Islamic inheritance. And a key point about that, the Islamic inheritance, that law or that equation is not determined until the person passes away, because you don't know who the heirs are going to be that are be alive at that time until that person passes away. So the F in FAITH is for your family dynamics. You have to know those better than anybody else. People come to my office asking questions all the time about, hey, I don't know your family. You know your family better than anybody else. You know everybody's strengths and weaknesses. So understanding your family dynamics is key. The A in FAITH is going back to assets. What are your assets? Taking stock of your stuff. The I in FAITH is for your instructions, right? As Muslims, our instructions are the Islamic inheritance guidelines, right? 2/3 follow your heirs Islamically. You have 1/3 that you can do a bequest to non-Muslim relatives, to charity, however you want to leave it. The T in FAITH is for, normally we say it's for a trust, but it's for what estate planning tool are you going to use? Are you using a will, or are you using a trust? And I'll take this time to explain the key differences between the two. All wills go through probate court. Whether it's an Islamic will, if it's a will you got off lawdepot.com, if it's a will you wrote on a piece of paper, if it's a will that my office drafted, it has to go through probate court. So a lot of people don't know that. All wills go through probate court. And that process, that delay I was talking about, that's probate court. How you avoid probate court. One way you avoid probate court, depending on your assets, you have beneficiaries named on all of your assets. That means at your passing, it goes directly to the person you name as a beneficiary. Right? Even with real estate, there's a new law that passed last July. Now you can name a beneficiary on your property. Right? The catch-22 on all of those things is that the beneficiary has to survive you. Right? If the beneficiary doesn't survive you, we're back in probate court. And so the ultimate way to avoid probate court is by having a trust. And a trust, all it is a legal document just like a will, but it creates a legal arrangement between you, your beneficiaries, and your assets. You set up this legal arrangement during your lifetime. You manage your assets the way you do right now. Nothing changes. And then at your passing, you would have nominated a trustee. At your passing, this trustee then manages your assets per the instructions that you give them, and they manage those assets for your beneficiaries. Yes, sir.
You said you put somebody as a trustee.
Yes, sir.
Do you have to have more than one of those? Just one person can be the
Gotcha. I'm going to repeat your question. He asks, when you nominate or appoint a trustee, if you're doing a trust, can it be more than one person? Should it be more than one person, or can it be one person? It can be one person. You can nominate one person, and you can nominate alternates, just in case that one person passes away or they're incapacitated or they don't want to do it. You can name two people if you want co-trustees. You can name two people. Yes. Okay. Then the H in faith is for help. That goes back to making sure you have a subject matter expert helping you through the process, right? An Islamic scholar that can explain and go through the Islamic inheritance laws with you. An estate planning attorney that can talk to you about the differences between the will and a trust, as well as the key documents that support those as well, like incapacitation documents. We know as Muslims that we're going to pass. We don't know when that day is, but we rarely plan for incapacity. So making sure you have a power of attorney where you nominate an individual or two individuals to manage your financial affairs in the event you cannot do it. Nominating a person to make medical decisions for you in the event you cannot do it. Naming people who can have access to your medical information, your bills and records in the event you cannot do it. Making sure you have a living will if it's determined that you're at the end of your life and you cannot vocally say what type of care you want, that this person can be your voice and say, this is the type of care this person said they wanted per this document. So making sure you have the FAITH, your family dynamics, your assets accounted for. What are your instructions? Are we putting all of that in a trust? Are we doing a will? And then making sure you have the help to guide you through the process. Does all that make sense? Alhamdulillah. Any questions?
Yeah, I had a question.
Yes, sir.
Power of attorney. Supposing power of attorney is not reliable as far as taking care of the business that the parents have them in charge of, and they're not handling the business properly. How do the other siblings go about being removed or make sure that they really screwed at the state?
Okay. So his question was, if someone has power of attorney and they're not doing what they're supposed to do, and correct me if I'm wrong, brother, this person has power of attorney over his parents. The siblings are concerned that their sibling is not doing what needs to be done as power of attorney. At this time, is the parent or are the parents incapacitated? Okay. So what the siblings can do, since they're not power of attorney, they can file in probate court in the county where the parents are living, and they can seek to be appointed as guardian or conservator over the parents. Either two siblings can do it together and the other siblings sign off on it. They can nominate one sibling to be the conservator or guardian for their parents. That would trump the power of attorney that the individual has. At this time, since mom and or dad are incapacitated, they cannot revoke the power of attorney, and they cannot assign somebody else that authority. So it will be incumbent upon the siblings to actually go to probate court, file for conservatorship or guardianship, and argue that the existing power of attorney is not doing what needs to be done, and somebody else needs to be appointed in this legal capacity that would trump a power of attorney. Got you. So the brother's question is, in my experience, if and when something like that happens, is that court process a long process? Conservatorship and guardianship, no, not necessarily. We actually just did a conservatorship for a brother in the community for his wife, who he's been taking care of since 2016, that's suffering from dementia and some other ailments. I think we filed maybe 2 months ago, and we just had a court date last week, and he's getting appointed. So the courts take that very seriously. Their thought is, if somebody's incapacitated and needs somebody to be appointed, they want to make sure that happens pretty quickly. There's still a process, but that should not take a year before a hearing happens and somebody's appointed. Yes, sister. Yes, ma'am. Okay. Okay. So the sister's question is about blended families. And let me make sure I understood you correctly. Is the question is, you're married into a blended family and you were to pass away, do the children that are not your children, do their mother get inheritance from you? Okay. Okay. That are not your children. Understood. That's a great question. My understanding is no, unless you leave them something specific, because they're not necessarily your heir.
What if their parent, let's say for instance their mother passed away, and now I've raised them?
Right.
What happens in that case?
Understood. If you raise them as your own, my understanding is that that will be considered an heir. An heir, yes. That's just my opinion. Just legal opinion, not Islamic legal opinion. Well, no, in the court of law, if we're talking not Islamically, in the court of law, if she did not adopt the child, that would be considered a non-heir to her. Just from my understanding Islamically, if she raised the child as her own, my understanding is that is an heir. I think somebody had a question. Walaikum assalam.
When you do a trust, can you do an amendment to it?
Yes.
Or how does that work?
Of course. So she asked the question of, if you have a trust, can you amend it? Which brings me to the very basic fundamental structures of a trust. And by show of hands, how many people are familiar with trust, have heard of trust? It's very popular now. A lot of people are talking about it. Okay. So you can have a revocable trust. And the word revocable means it can be revoked, which means it can be amended, it can be changed. Then you have irrevocable, meaning you cannot change. You cannot amend it. You cannot revoke it. So 99% of people do the revocable trust because it gives you the authority and control during your lifetime. So everything stays status quo like now. You still pay your mortgage. You still go access your bank accounts. You still drive your car. All those things stay the same. That trust is generally used to avoid probate court. It does not provide any asset protection for you during your life. And the reason because you can change it. So if you can still access the assets that you put in that trust and change the instructions, the thought is your creditor should be able to do the same thing. They should still be able to seek recovery of a debt if you can still access and move the things. When you do an irrevocable trust, you're giving up authority, control, ownership, power during your lifetime. So if you did an irrevocable trust, you would name a trustee to manage it that day. Now it's no longer yours. You cannot change it or amend it anymore. That provides asset protection for any asset you put in that trust because, again, you're giving up ownership. You're giving up control. Generally speaking, again, 99% of us do not need an irrevocable trust. But for the trust you can amend, the revocable one, yes, as time changes, maybe the family dynamics change, assets change, you want to update your instructions, you can definitely amend a revocable trust. Any other questions? Yes, sir, brother. Right here.
If you have assets and somebody wants to sue you, are they able to get to the assets in your trust?
If you have which one?
Irrevocable.
Right. So if you put assets in an irrevocable trust, the one that you cannot change, the one you're giving up ownership, authority, and control, generally speaking, if somebody sues you, you don't own it.
Right.
So it's not even going to be a part of the equation.
Revocable.
Irrevocable.
Irrevocable.
Right.
Yeah.
Now there's a catch to that.
Okay.
Right. Say we're in a parking lot and you hit me. Now the thought would be, I have a legal action against you. Tomorrow you go create an irrevocable trust. I'm going to argue that you created that for the sake of defrauding me so I can't get anything. So most states have a 5-year look back period. So there are plenty of people that call my office, oh, I have this, lawsuit pending. I want to move my assets. I'm like, yeah, I'm not the person to do that for you because I'm going to charge you to do it. And there's still a likelihood that it still gets caught because you moved it after you were notified of an issue. Yep. Yes, sir.
How do we know which way to go as far as will or trust? How can we get the
Right.
correct information for my family to say, okay, I want to do it this way,
Right.
or I want to do it the other way?
Right. I always say this. When you look at the family, you have to, going back to the faith, that's why we use that acronym. Your family dynamics, your assets, and your instructions should always dictate what tool you use. Right? I always tell people, if you have minor children or minor grandchildren that you want to inherit, if you leave an asset to them in a will, they're not going to get it. They're not old enough to get it. So somebody would have to be appointed their conservator to hold that asset until they turn 18. You could have just got a trust. The trust would have held it until you said a certain age.
So that would be a trust instead of a will.
Going back to your family dynamics and what your assets are and what instructions you want to be in place,
Okay.
right? That will dictate what tool you use. So I always tell people with blended families, if you have a blended family, brothers with 2 wives, minor children, should definitely consider having a trust, right? Based on your assets. Again, I did say Georgia just passed a law last year where you can name a beneficiary on your house now. But based on your assets, if you don't want a particular asset to go to just one person, meaning if I name one person as the beneficiary on my life insurance policy, there's no guarantee that they get that money and then blow it. If I don't want to make sure they don't blow the money, I need to make sure that flows through to a trust. And I name the trust as the beneficiary on that life insurance policy. And now my trust instructions say how that person can benefit from the money. Does that make sense? Okay, alhamdulillah. I'm going to get her right here. Yes, she asked the question of, essentially, can you name a trust as the beneficiary on a life insurance policy? Yes, you can. So once you have a trust that's established, this is a part of the funding process. I'm not sure if you guys heard of trust fund baby, that type of stuff. The trust fund is literally, what does the trust hold? What does it own? What does it have? So the funding part is the assets. And how you make sure a trust that is created is funded is by either changing title to assets during your lifetime, meaning you have real estate, so now the real estate is owned by the trust. It's still owned by you as trustee, So it'll be your name as trustee of your trust. That's the owner of this home now. So on life insurance policies or bank accounts or retirement accounts that can actually have a beneficiary name, the trust is the beneficiary. That means at your passing, the trustee you named in that trust submits the death certificate, beneficiary claim form, trust certificate. They cut a check to the trust. The trustee puts that check into the trust account. They're often following those instructions, what to do with that money. Yes, sister. Yes, ma'am. Mm. Yes. Yes. Okay. Thank you for that question. Her question is, she's one of 5 kids. She's the only Muslim. Her siblings are not Muslim. And she has a multi-faith family. Her question is going back to the Islamic inheritance rule and laws and guidelines. Essentially, upon your passing, how would your assets be governed or divided if you have family members who are not Muslim? It is my understanding that non-Muslims do not inherit from Muslims. However, within the Islamic guidelines and Islamic rules, a third of your estate can be distributed to non-Muslim family members. Now, if you're the only Muslim in your family, the question is what to do with the other 2/3. You're supposed to, if there's no Muslims in your family, to leave it to charity, Islamic causes. Alhamdulillah. Okay. But just for the sake of just continuing that conversation, Islamic causes, charity, and that such. But you are able to leave at least a third to non-Muslim relatives. Yes, sister. Yes, so going back to the Islamic inheritance shares, which is in Surah An-Nisa, verse 11, 12, and 176. And I won't go down what the share breakdown is. But if there's a non-Muslim heir, they're not supposed to inherit as a Muslim heir based on the inheritance guidelines. However, there is a third of your estate that can be distributed to a non-Muslim heir. So you could utilize that third for a non-Muslim child if you wanted to. Yes. Yes. Walaikum assalam. Thank you, sister.
If, say I had a trust and I wanted to ensure that my son marries an African American, is it against the law for me to stipulate that he couldn't receive funds unless he marries an African American?
Great question. So her question was, if she if she got a trust and she wanted to include an instruction that her son, who's African American, must marry an African American woman, is that against the law? Well, that's a great question. Well, obviously we know, I don't know, we know the Loving v. Virginia case that outlaws discrimination, but I think that's more or less about people who do marriages cannot not give a marriage certificate because it's an interracial. I think, let me back up. Trusts are private, right? It's not public. So that's another difference between a trust and a will. When you file a will in a probate court, it is public information. I can go look it up and see it myself. When you do a trust, it stays private within the family. Now, for her question, yes, she can include that instruction. However, if her son wanted to marry a non-African American woman and he knew mom had that instruction in her trust and he thought it was unlawful, could he sue? He could bring a lawsuit. Whether or not he would be successful, I don't know. Yeah.
Assalamu alaikum.
Walaikum assalam.
Can you name a non-Muslim relative, like your nephew or niece, in your insurance policy as far as being a beneficiary of some of your insurance, your policy? Can you do that?
So her question is, as a Muslim, can you name a non-Muslim nephew or niece as a beneficiary on your life insurance policy? Going back to the Islamic inheritance rules, a third of your estate can be distributed to non-Muslim heirs. So assuming that's a third of your estate, I think you're okay. But then you have to think about the other 2/3. So if all you have is that life insurance policy, right? That is a question, and that's a conversation between you and Allah. Yep. Yes, sister. Understood. Understood. Got you. Right. So the question about that is, that's a good question. This goes back to the inheritance shares, which I did not go into detail over. I'm not certified to go into detail over that, so I won't go into detail over that. But I will say this, again, that equation is not determined until somebody passes away. So I understand your, conflict. But rest assured that at least a third can be left to mom, right? But that is a good question. Her question or her comment was, she's a revert. She's Muslim. Her dad is Muslim. Her mother is not. She does not have any children at this time, and she, God forbid, if she were to pass away, she would have wanted to leave all of her stuff to her mother. And so she just wanted to understand the inheritance guidelines around that. So, inshallah. Any other?
Assalamu alaikum.
Wa alaikum assalam.
I hear you speaking about Muslims giving to non-Muslims. Are Muslims allowed to receive from non-Muslims, either through wills or trusts?
Right. Great question. It's my understanding. Again, I think it happens. I don't know anybody who's Muslim that would inherit $1 million from a non-Muslim relative and turn it away. Only because there's causes that can be, obviously funded with those funds too. So I don't know the answer to that question, sister. Based on my research, is that Muslims don't inherit from non-Muslims, but I don't know the Islamic legal answer to say if a family member who's non-Muslim left you something, are you to reject it? I don't know the answer to that. My gut and my legal mind says you can accept it because they left it to you. And then obviously as Muslim, again, our wealth is a trust from Allah. What you do with that money, I think, is what you're judged on. That's my opinion. Yes, sister.
Piggybacking off of her question, because we all have family who
Mhm.
are technically considered people of the book, right?
Yep.
So, what is the distinguishing language to determine, is it Muslim versus non-Muslim? Is it believer versus disbeliever? Is it believers in God versus rejectors of faith? Like, what is the determining language? Is it Muslim or non-Muslim? Is that the language that is used? Or is it a little bit more vague and referencing more like believers, which could technically include the people of the book?
Understood. That's a great question. Unfortunately, I don't know the answer to that question. Based on my research, I believe it's Muslim, somebody who's taking Shahada. But I will definitely do more research on that question. That is a great question. Her question was essentially a lot of Muslims, especially African American Muslims, a good bit of our family are non-Muslim. But they may be Christian, they may be of another faith, and they would be considered a person of the book or a believer. And so are they included when we're talking about inheritance? If they're a believer, is that sufficient, or do they have to be Muslim, one who has taken Shahada? That is an excellent question that I'm going to find the answer to, inshallah. Yes, sister. I'm going to repeat it. No. So it's my understanding. So the question she asked, when you're doing a trust or a will, whether or not you have to name a Muslim to be the person to oversee your estate. It's my understanding that that's not a requirement. Yes. And sorry to answer that question though, but going back to the Islamic inheritance and Islamic rules and laws, I do think whoever you choose should be somebody you trust, keyword, and that has the wherewithal to either know what they're doing or to ask questions and go get the information they need to make sure they're carrying out the instructions properly, right? Whether, and I mean, we're Muslim, and I know that what I'm saying is follow Islamic, inheritance guidelines. There are Muslims who don't do that. That's between them and Allah. That it is what it is. But regardless, if you do a will or you do a trust, make sure the person you nominate to carry out your instructions, just make sure they're a good, honest person. I think that's important. Yes, brother.
Regarding trust, when you nominate a trustee, that like when do they actually trustee that when you pass?
Got you.
Also, regarding the trustee, is that person, is that a specific person, or is that like an entity that
Got you.
trustee?
Got you. Okay. So it's, oh, sorry, go ahead. No, he has 3 questions. Go ahead. Alhamdulillah.
And I know there trustee capital.
Got you. Okay. So he has 3 questions. The first question is the trustee that you name when you're doing a trust. When does their role and responsibility kick in? If you're doing a revocable trust, the one you can change during your lifetime, you're the trustee. So in the event of your incapacity or at your passing, the baton is then passed to that successor trustee that you named. If you're doing an irrevocable trust, that trustee takes right then and there. Yep, they take control over the assets at that time. The second question, I'm sorry, what was the second question? I remember the last one. About. So that was okay. So I remember the second question. I'm sorry, I remember the last one too. The second question was, is the trustee an individual? Can it be an entity? What is, it can be an individual. There are financial institutions that offer trusteeship. And so generally speaking, that's called a corporate trustee. Generally speaking, a corporate trustee, the estate value needs to at least be $1 million before, because they're going to want to get paid. A corporate trustee definitely is going to get paid. And so your estate value would have to make sense for them to serve in that role. Now, if it's your brother, your parent, a trusted colleague or friend, that's up to you if you want them to be paid. Your trust instructions can say they are not to be paid. Your trust instructions can say they're paid something reasonable. But most trust instructions do say they should be reimbursed for any out-of-pocket costs that they may incur. So whether or not you want to pay them a flat fee for the role, a monthly fee, they get paid out of the trust funds based on maybe how the trust does, because some trust assets are invested and maybe they get paid out the investments, right? And so that will be your right to do whatever those instructions are, inshallah. Yes, sir. Got you. Okay. I remember your question. I did forget one question he had. Is it advisable to have a revocable trust and an irrevocable trust, and can you do both? Yes, you can do both. I always tell any individual that comes into my office, because a lot of people are on social media and they heard about this wonderful irrevocable trust, you need to start with the revocable trust for family planning. You start with the very fundamental basics. Now, whether you need an irrevocable trust, that's discussed at that meeting. You might not need it. Again, a lot of people are on social media. They're selling things and it sounds great, but then when people hear exactly what that does, what it means, how much it costs, it doesn't make sense for what they're trying to accomplish. But we have clients that have the revocable trust, and then based on where they are as far as their estate value, based on their income, based on their need for privacy, their need for asset protection, we do an irrevocable trust as well. Going back to your question, brother. His question was, if you do a trust or when you do a trust, can you name a successor trustee and then alternates? Yes, you can name as many alternates as you want to. His other question, I forgot it. I'm so sorry. Yes, okay. If you live in the U.S. and do a trust here, but you have assets overseas, well, if that were the case, you would not put any assets overseas in the U.S. trust. I would not tell you to do that. Okay? Because that could subject it to U.S. taxation, which you don't want. So there are obviously domestic trusts, then there's foreign asset trusts, there's offshore trusts for asset protection. So I always suggest, depending on which country, that's going to dictate how that asset in that country maybe is connected to any U.S. trust. I have some clients that have assets and property in Ghana, right? It was like, we need to consult with an attorney in Ghana that does estate planning, because their estate planning laws are not our laws. So we always make sure that we're following the laws in that country, and then making sure that through that we can match it with the needs of this trust is, to make sure the person's wishes are still carried out. Inshallah. Yes, sir. Right here, brother. Wa alaikum assalam. Alhamdulillah. Mm-hmm. Okay. So this question was about debt, and I'm going to talk about the will first. Again, all wills go through probate court. So when you have a will, your family is in court, your creditors are in court. So trust and believe your mortgage is going to be paid one way or the other. The mortgage company will be a part of that court process. Credit card companies, everybody will get their payment. Whether they get all the payment or they concede to some of the payment, they will get paid because they would have learned that somebody passed away. Also, when you do probate, generally speaking, the executor, the person that files the will, or the administrator, if you don't do an estate plan at all and somebody has to be appointed, they have to do a notice to creditors. That runs through the publication process, and then creditors have essentially 90 days to file into the probate case. So creditors generally are going to get paid. Going back to just being Muslim, right, we're supposed to make sure our debts are taken care of anyway. And so when you do a trust, what we often see and what we often advise for our clients that come in, hey, I have a property, I have a mortgage. Okay, well, do you have mortgage insurance? Well, you want to make sure if you want to leave this property in trust that you're not leaving your family with a mortgage. Because most people, if you leave me a property with a mortgage, I'm going to sell the house. I'm not going to pay that mortgage, especially if you don't leave me any other money to pay the mortgage. You're leaving me debt, right, that I have to pay for. What's my incentive to take care of the property? If I'm not in a financial position to pay the mortgage, I'm better off selling the house, which you may not have wanted me to do. So that goes back to having that conversation with the family. A lot of times people come in, I want to leave this property to my child. The child don't want the house. They don't want the house. Have the conversation. Let them tell you, I don't want the house. Okay, now you need to do something else with it, right? Maybe your instruction is the house needs to be sold, right? And so, right, but again, if you want to leave a house with the family and your family wants the house and there are assets or other liquid cash assets to pay off the mortgage, then there's a question, are my instructions that the mortgage is paid off? So now my family has this house free and clear. Are they in a financial position to pay for the mortgage? You have to, again, going back to your family dynamics. What are these people's, the people in my family, their capability? And they pay it. Are they willing to pay it? You can also include instructions at any point in time if they do not have the ability to pay it and there's no money from my trust to cover it, the house should be sold. You don't want to leave, you don't want to leave a burden for the family, right? You want to leave an asset. And so that's where the instructions kick in. How do you do that? Inshallah. Yes, sir. Oh, I'm sorry. He had his hand up. I'm sorry, brother.
Several questions about will. One,
Okay.
If there's a shared asset identified in multiple wills, sort of overlapping, is that, how is that sort of sorted out? Piece of property is
Okay.
identified in more than one will.
Okay.
One will take precedence over the other.
Okay. Okay. So this brother has two questions. The first question is, if a will is notarized and the notary expires and then the person passes, is the will still valid? So for a will to be valid in Georgia, it does not have to be notarized. So that's to know. It does not have to be notarized. It helps strengthen the will, of course, but it doesn't have to be notarized. But no, it does not invalidate the will if when it was signed and notarized, it was in 1995 and the person passed in 2026. It's still a valid will, despite when it was signed and despite the notary date. His second question was, if there are multiple wills and each will mentions an interest, that person's interest in the asset, is the question which will takes precedent? If there are multiple wills, let's say there's a will done in 1990, there's a will done in 1995, there's a will done in 2010. The 2010 will, and let me go back up. Do all the wills mention the same asset? The latest will should take precedent. Now, there could be conflict there. I've seen it myself. I've had they're not Muslim, but I had a family come to me. The mom passed. She had a 1990 something will that laid out certain things, and then she had a 2016 will that laid out something totally different. And so you can imagine heirs that were listed in the 1990 something will that are not listed in the 2016 will are like, what's going on, right? So then there's a conflict that plays out in court. And so I always say, when you do a new will, destroy the old ones. Destroy the old wills so there's no conflict. Another way to protect, if you're going to do a will, you can file a will in advance with the court. And the court holds it for safekeeping. It's not filed for probate because you're still living, but it's filed for safekeeping. So the court can hold it, and you can let the family know. So upon the person's passing, hey, we filed this will, this 2010 will, the person passed 2026. This is the will that they filed. This is the will that should go forth. But I would say, if you have copies of old wills, please destroy them if you get a new one to avoid any potential conflicts. And yes, sir.
I actually meant it slightly different.
Okay.
In that there, let's say there are children
Mm-hmm.
that identify a shared property
Yes.
on each will. So brother, sister, the other brother, each have their own individual wills. And that shared property is identified on each will.
Understood.
Does the description of that shared property on each will, is there a precedence in terms of how that would be executed on each will? So brother one passes first, but describes the shared property differently than the way that it's described on will, sister wills too.
Okay.
Will to the other one.
Okay.
Is that
Okay, I want to make sure I understand your question correctly. Are you saying that, just for example, there are 3 siblings, they each own a third in a piece of property?
let's say it's not described as such as a third.
Okay.
Let's say it's described as owning the property.
Gotcha. So their will, their only will just says, I own such and such property at this address. And then the other person's will says, I own such and such property at such and such address. What's going to govern is the deed. So if the deed has all 3 of their names, and we're in Georgia, and it does not say with joint rights of survivorship, it's automatically assumed that each own a third. So if brother 1 dies first, that probate through that will is just his interest, which is a third, and that's it. And then so forth and so on. If the deed says joint rights of survivorship, at brother 1's passing, the 2 siblings automatically now 50-50. There's no probate. Even though your will says you own interest in that property, your will would go through probate. They will look at the deed. That property is not going to be a part of your will and your estate and your assets because of the way the deed reads. So that's key and very important to know how a deed reads. That's another thing that people do. They do joint rights of survivorship on deeds to avoid probate court as well. I think the young brother, did you have a question? Right behind you. Right. So you can do different people do different things, right? There is mortgage insurance that you can have specifically for a mortgage. And then some people just do term life insurance that match the term of the mortgage. So let's say you have a 30-year mortgage. I just get 30-year term life insurance, but I'm specifying in my instructions that this is only for the mortgage. That's what I got it for. So it really just depends, but there is mortgage insurance. There is a specific thing like that. Gotcha. Yes, sister. Yes. Mm-hmm. She has a question about air property, and I will tell you, air property is nuanced because essentially somebody in the lineage passed away, and I get this question all the time. My great-great-granddaddy passed away. He left 200 acres in Alabama, and it's 50 of us. Okay. Heirs property is very expensive. Somebody has to survey the land, and if great-great-great-granddaddy never did a will, which most people did not, and generally going back heirs property, they grew up on the land, the family grew up on the land, and nobody bothered them. But when you get into modern day, now I own a 15th interest, or I own a 50th interest, I want to make sure my interest goes. Well, we have to make sure your interest is actually legally vested to you. So now we got to reach back, we got to go through probate to make sure title actually passed the way it was supposed to. So that is time consuming, that is very expensive. And generally speaking, again, it's normally in rural areas. You have to get an attorney that's versed in that in that area, that knows the court system, that knows, so not to discourage it. I think people should go through the process, because if you own land and you're entitled to land, you better go get your land. Just know it's a process. I don't do heirs property though, but I get the question a lot. Mm-hmm. Okay. Yeah. Understood. Yeah, and a lot of issue with that is that over time, some of the heirs start selling to outsiders too. So it's really like who owns what, you have no idea, and that's where it gets very nuanced and complicated. Yes, back there. Walaikum assalam, sister. Mm-hmm. Great question. Yeah, great question. I'm glad you asked that, because that brings me to a point. So when we're talking to, whether it's a family, a single person with minor kids, anytime there's minor children involved, we always advise our clients to do a kids protection plan. That's where you can nominate a temporary guardian. God forbid you're incapacitated or you passed away and that kid is still a minor. You can name a permanent guardian. Same reason. God forbid you pass away and they're still a minor, or you're incapacitated and they're still a minor. You also can nominate a person as that minor's power of attorney medically, right? Because if you're incapacitated or you're not alive anymore, a minor cannot make medical decisions for themselves either. Now, in a situation where I always tell people, a lot of clients come in and maybe it's a strained relationship between the parents, or the father's not involved, or the mom is not involved. You cannot legally take a parent's right away, meaning the nomination you do does not guarantee the person you nominated to be that child's guardian. It strengthens their chances, but in the court of law, if it goes through the court of law, which it will always when there's a minor child involved, the biological parent always has first rights, right? But it will be up to that judge and the family and the circumstances to argue why the parent should not be the guardian. But that goes back to having a trust. If the biological parent were to become a permanent guardian of a minor child, and you did not want that parent to have the money, to oversee the money, having a trust will prevent that. When you have a trust, the trustee manages the money. It doesn't matter who the kid is with. It doesn't have to be the guardian you nominated. It doesn't have to be the parent, the other parent, who you may not trust with the money. It would be the trust that governs how that money benefits that child. It wouldn't be the parent being able to dictate that. Does that answer your question? Alhamdulillah. But just going back, as I said earlier, when it's a minor child, and I always use your best judgment. If the minor child is 2 versus 16, okay, they're 16, they're almost an adult. But you can imagine you don't want an 18-year-old inheriting a lot of money at one time. You don't want them inheriting a house they probably can't take care of. And so, and again, anybody under the age of 18 cannot inherit directly. The state does not allow that. And so having that trust safeguards that asset, one, and it also protects that minor child, two. You also have to take into consideration that if a minor child is set to inherit, or any family member is set to inherit, you want to protect them, because when you have a trust and you leave an asset in the trust, it protects the beneficiary from their creditors. So if your beneficiary has debts, if your beneficiary has issues, if the asset is in a trust, it cannot be touched by their creditors. It cannot be touched if they get divorced. It cannot be touched if they have a financial problem, or, God forbid, a substance abuse issue or mental issue. The trust protects it from themselves as well as outside people. As you can imagine, if somebody were to set to inherit $1 million, there'll be people around them with their hand out. If they don't have it liquid cash to give out, they can't give it. The trust guards it and protects it. So it's protecting them and protecting them from other people. Yes, sir.
So my question, I'm a little confused because I guess the difference between trust,
Yes.
will, and you also mentioned power of attorney,
Mm-hmm.
surrogate, guardianship, like all of these under one umbrella, trust.
Gotcha.
Or things different
Gotcha.
should have.
Gotcha. So they are separate. They can work in concert together. Everybody should have power of attorney documents. Once you turn 18, you should definitely have power of attorney documents, because we never know if we're going to be incapacitated. And I say 18 because most 18-year-olds have a bank account, they have a phone, they have certain things. And if they were to become incapacitated, their parents cannot go to their bank and get their information. They're not going to give it to them. Islam alaikum. A parent can still make medical decisions for them because they're next of kin, but they can't get in their phone, they can't access their accounts. They have to have power of attorney. So everybody should have power of attorney. Now, whether you decide to have a will or a trust, that's up to you, depending upon how you want your assets to be governed and distributed at your passing, or governed and distributed in the event of incapacity. A will does nothing until you pass. That's why you would need incapacitation documentation. A will does nothing until you pass. It's just a piece of paper. Once you pass away, now it can be used. Otherwise, it just sits there until you pass away. Power of attorney does nothing unless you're incapacitated. Right? You can dictate in that power of attorney that this springs into action. We call it springing. It springs into action if and when I become incapacitated. Some people, depending on how old they are, they're married, hey, this power of attorney can be active now. I want my wife to be able to go access stuff now, just in case I don't feel like doing it. She can go do it, right? So you can have it right now, or you can have it springing. The trust governs all those things. Trust avoids probate court. It gives instructions on what to do with your stuff in the event of incapacity. Any asset that you didn't change the title to your trust, your trustee and your power of attorney can work in concert together in the event of incapacity. At your death, the power of attorney dies too. There's nothing else to do power of attorney wise as somebody's passing. Does that help answer the question?
So, should you have trust in or just
Gotcha. Great question. Should you have a trust and a will or one or the other? Generally speaking, especially at my office, but most of my colleagues that I know that do trust, they always include a will. We always include a will because it's a safeguarding measure. Going back to the trust fund, right? When you have a trust, it has to have something in it. If you do a trust and never put anything in it, I won't say it's pointless, but it's kind of pointless. You create a trust to make sure probate court is avoided. How you do that? Changing title to assets that you can change title to during your lifetime, and then making sure other assets point to the trust via beneficiary designation, right? But life happens. We have no idea again if and when we will pass. And so when we do a trust, we do include a will as a safeguarding measure. And what I mean by that is, God forbid a trust was created, and before we could fund it, the person passed away. You want to make sure those assets still are caught. So that will that we do, it catches the asset. It's called a pour over will. Since it's a will, it has to go through probate court. But it tells the probate court in the will, I have a trust. Essentially, it takes 8 pages to say this, but I have a trust. Pour whatever asset that didn't make it into my trust and let my trust still govern. So we do include the pour over will as a safeguarding measure. Our goal is to never ever have to use it. I think so far, unfortunately, we did a trust for a guy. He was sick. He didn't allude to how sick he was. We were able to get his property transferred into his trust, but his daughter, who we nominated as power of attorney, didn't have time to change the beneficiaries on his bank accounts to his trust. And he passed away during that time. And so now she's in probate court for the bank account stuff. So, yes, sir.
You say you have the will in the trust. Add that to it.
So when you have a trust, we do include a pour over will as a safeguarding measure. It's not like the typical last will and testament that you plan to go to probate court with. It's just there just in case.
In the trust, you said it's private, nobody can see it. So would they do the same thing? Could they still see the will that's involved in the trust?
Right, so will the trust still be private? The trust still is private. Now that will is not private, but the will doesn't list like all the information of your assets. It just says I have a trust. Pour the asset over into the trust. Now through that probate court process, will the asset be uncovered? Of course. So if somebody's really digging and trying to find out, they could find it, but the will itself doesn't list like the private information. Yes. Any questions? Yes, sister. Oh, I'm sorry. Well, yes, sir. Back, yes, ma'am. Back there. Great question. Which? Okay. She has 2 questions. Which documents in Georgia do you have to be notarized, and can you get these documents offline? The financial power of attorney has to be notarized. Generally speaking, the medical power of attorney has to be notarized. The healthcare directive, which is Georgia's living will, which dictates what happens or what care you get at the end of your life, that does not have to be notarized. Those 3 forms you can find offline. If you literally Google them, you can find the form offline. I don't think there's anything wrong with doing that. I just always encourage that you do seek legal advice to make sure you understand the document. A will does not have to be notarized in Georgia. It just strengthens the will to say that I had these 2 witnesses, this person notarized it. It just also says I had the capacity to sign this, I wasn't under duress. It just strengthens it, but it's not necessary. If you do a trust has to be notarized. You can find all those online. You can find a trust on lawdepot.com. I don't encourage you to do that, but you can find those things online. I'm going to lick my slime. I think it always depends on your assets. I would say this. I've seen more family conflict with people who got a will offline versus who went to an attorney and got it done. And you have to understand that because generally speaking, the way you can contest a will is I don't think it's valid because they didn't sign it. That's not their signature. I don't think it's valid because they were under duress or undue influence. I don't think it's valid because they didn't have the capacity. They were diagnosed with dementia. How you prevent all that? If they come into my office, I'm checking all those things. Do you know what today is? What's your name? You know, I'm not going to sign anything or draft anything for somebody who does not have the capacity for it, right? And so I think I see less challenges or contest to a will when an attorney does it or at least reviews it, right? So now could you get your will offline and take an attorney to review it? You can. There are some attorneys who are not going to review a will they didn't do, but you can try that. I just think it really just going to depend on your family dynamics. Or do you know somebody that's a knucklehead that's going to contest it? I don't know. So I think you just have to really do your due diligence about that. When you can get offline, of course, but just making sure that it's not going to be contested, and you never know if that's going to happen until somebody passes away. So. Gotcha. And again, sister, that's going to be your prerogative, right? I don't think as an attorney, I'm never here to sell anything, right? So I'm not going to tell you have to have an attorney. You don't have to have an attorney. I think it's wise in certain circumstances to have an attorney, but that's when you have to think about what are my family dynamics, what are the assets I'm leaving in this, what are the instructions I'm leaving. I think in that regard you have to ask yourself, is my family best suited if I use an attorney to do this for added potential protection? And going back to her, just to make sure that everybody understands, when you do a will in Georgia, the witnesses cannot be an individual that's named in the will. They have to be disinterested, meaning the people you name as beneficiaries, they cannot be witnesses. If they are witnesses, they automatically disinherit themselves unless you have a third witness. So in Georgia, it has to be 2 witnesses. They're supposed to be disinterested. But if they're interested witnesses, meaning they're people you named in the will as beneficiaries, you need a third witness. Because then the question comes in, did they make you sign this? Did they forge it? So you want to make sure you protect yourself if you do a will. And I'm going to get to you, brother. She had a question right here. If you can do what? I'm sorry. Gotcha. So if you create one trust, can you name multiple beneficiaries? I see what you're saying. So if can a family create one trust? They can, but I caution that only because it depends on what type of trust you're talking about. If it's revocable, absolutely not. Can they do it? Yes, I would say don't do that. Because again, it does not provide any asset protection. Let's say mom, dad, you, sister, put all your assets into one revocable trust. Well, who's the trustee? All you guys are the trustee? If you get sued, now everybody's assets in this trust they're up for grabs because you did something wrong. And then when we're talking about putting real estate in a revocable trust, who's claiming homestead exemption? So I always say, now can one family create an irrevocable trust and put assets? Yes, of course. But I would not advise it for a revocable trust. There was a hand in the back on the sister side, I think. If not, then you had a question, brother.
So, regards to the trust, if you have assets in another state,
Mm-hmm.
or if you later decide to move to a different state than your current state, how does that work? Right? You have to trust in the state.
Gotcha.
Trust in the state.
So let me answer the first question. And great point. I'm glad you brought that up. It's very important that you consider a trust if you have assets in more than one state. Why? Because if you do not have a trust, now there's multiple probates in multiple states. One trust can hold assets in multiple states. So let's say you live in Georgia, you create a trust in Georgia, you own real estate in New York. That real estate in New York can be in your Georgia trust. If you do no trust, now you have probate in Georgia and probate in New York. Right? Now the question is, if I live in Georgia and I move to New York, do I keep my Georgia trust? You can amend your trust to now reflect New York law if you want to. So you can always amend it based upon where you live. So that goes back to the revocable trust. You can amend it to reflect the state law that you're currently living in. Does that answer your question? Okay, alhamdulillah. Yes, sir, brother.
You mentioned that to get a corporate trust, you have assets. If you want to get a non-corporate trust, that one thing is recommended for the trust, or need to go through an attorney.
Mm.
Is there like a certain
Estate value, asset value. Got you. Great question. His question was, I mentioned earlier, when you're looking or considering doing a trust and you're thinking about naming a trustee, do you consider naming a person you know or a corporate trustee? And I made the comment that most, and I'm not going to say that this is law, I just can imagine a corporate trustee is not going to agree to fulfill that role if there's not sufficient assets to pay them. So most times it's, yeah, your estate value needs to be at least $1 million to make sure I can get paid for this role. His question was, well, if your estate value isn't at that threshold, when should you start even consider doing a trust? I always say that goes back to the family dynamics, goes back to your assets. What are those assets, right? And then goes back to your instructions. And the family dynamics are very important because let's say all I have is a house. It's not worth $1 million, right? I have a mortgage, but I have equity in my property. And maybe I have life insurance that, could pay the mortgage off, but it's still not $1 million. The question you ask yourself is, okay, do I want my family to go through probate court? Right? Because if the deed is not titled a certain way, meaning, let's say you're married. If you and your spouse don't have joint rights of survivorship, that means at your death, it goes to probate court. If you have joint rights of survivorship, that means at your death, automatically wife is 100% owner. But now the question becomes, what if she passes away? We're back in probate court. Now, I always say you have to look at the family dynamics. If there are minor children that you want to make sure are taken care of a certain way, you want to leave them a certain amount of money or certain interest in an asset, the only way that's going to be carried out for sure is through a trust. So I have plenty of people that come to see me, well, this is all I have, and, I just want, my kids are grown, they can take care of their own kids. I'm not leaving anything to my grandkids. I want my kids to get everything. Do I need a trust? What do you have? I have life insurance, I have retirement, I don't own any real estate, and I have bank accounts. You don't necessarily need a trust. If you want everything to go directly to your children, just name them as the beneficiaries on the accounts. That solves that problem. Again, I'm not here to sell anything. I'm here to give the advice, and you can tell me, well, this is what I want to accomplish. Okay, well, based on what you want to accomplish, you need a trust, right? That's how that conversation goes. Or based on what you need or what you say you want, a lot of people come in, I want a trust, I need a trust. No, you don't. And I'm going to tell them that. You don't need that. Now, if you want to pay me to do it, okay, but you don't need it. So it always depends on what the goal is. I can't say there's a certain dollar value because it's always going to depend on what's the asset. If you don't have any assets, then you don't need a trust for sure. You don't need one. You don't have anything, right? But if you have stuff and you have instructions and you have minor children, or you want to make sure that I don't want this person to get this life insurance policy outright because we know within 3 years 70% of inherited wealth is gone. It's not making to the next generation at all. So if you want to make sure it's protected over a period of time, only a trust will do that. So it's really going to be, what do you want? What are your instructions? What are your goals? And those are the things we cover during like a planning session at my office. We talk about all those things, and so you can make an informed decision. I'm not going to tell you anything. I'm not going to dictate anything to you. You tell me what you want to accomplish, and I tell you the tools you can do that with. And then you make your decision, inshallah. Yes, sir.
So I understand when you set up a trust, you're supposed to choose somebody that you trust, right? But say they decide to do, they decide to not follow your instructions. Is there something to kind of
Right.
correct how they choose, or
Yeah.
is it kind of just that's
Gotcha.
beneficiary says, hey, the trustee isn't doing it, it's just like they do whatever.
Gotcha. Great question. So if you have a trust and the trustee is a wild card, right? What's the recourse, or how do you prevent that from happening? So there's a couple of ways to prevent, or measures you can put in place to hopefully prevent that from happening. So when you're creating the trust or establishing the trust, you can name a trust advisor. That's a separate person from the trustee. You can also name a trust protector. That's a separate person from the trustee. That trust protector is there to oversee what the trustee does. Right now, obviously, a trust protector might want to be paid too, right? Trust advisor, generally speaking, for clients of mine, me and my office are the trust advisor because we're the ones that established the trust with them. I kind of know what their goals and intentions were, and I can be there to advise that successor trustee on, well, based on my conversations, this is what they wanted to accomplish. So this is the way we could potentially still accomplish this within the trust instructions. I don't have to be the trust advisor, though. Also, we always encourage our clients to have family meetings, and sometimes we facilitate that. And we're also often working in concert with your CPA, your spiritual advisor, your business coach, your financial advisor. So there's no question about what your intent was. There's no question about what the roles and responsibilities are for the trustee. There's no questions about your instructions. And during that process, we're educating everybody. We're educating the beneficiaries, of course, as they come of age, right? Because if it ever came a point in time that a trustee did not fulfill their obligation, they broke the law, whatever like that. As a fiduciary, they have a legal responsibility. So if they don't do that, they can be sued. Does that help? Okay, alhamdulillah. Any questions from? Yes, sister.
You know, what's the non-heritage to this person's daughter if he doesn't like her husband? She can always terminate him if she divorces him or if he dies.
My understanding, based on the Islamic inheritance guidelines, Muslims inherit from Muslims, and you cannot deny a Muslim their right to their inheritance. Right? Now, you're not supposed to do that. Now, if somebody does that, that's between them and Allah, of course. But even if somebody's a Muslim and they're not practicing, somebody's a Muslim and they have a substance abuse issue, if somebody's Muslim and they're, maybe you don't like them that day, you're not supposed to disinherit a Muslim. They're supposed to get their share based on the Islamic inheritance. So no, he's not supposed to do that because he doesn't like her husband. But I can't say that he won't do that, right? Any other questions? Comments? Yes. Okay, great. I haven't even been paying attention, so alhamdulillah.
One person asked if does a financial account with a POD,
Mhm.
payable on death, have to go through a probate court?
No. So a bank account or any account that has a payable on death beneficiary will avoid probate court because that's a beneficiary. When a beneficiary is used, that avoids probate court. The only way it could end up in probate court is if the beneficiary passed away before they were able to get the funds.
It's hard to go back, like
Yeah, it's okay.
questions and then the answer.
Yeah, no worries.
It's not, I think it's
Okay. Go ahead. I'm sorry.
because I was with somebody that's beneficiary and I'm like, but my will says something else. Is that responsibility?
No. So if you name a benefit, let's say you do a will and you list all your assets in the will. My house is such and such, my life insurance is such and such, my retirement is such and such, my bank accounts is such and such. But all those assets I just named have a beneficiary on it. The beneficiary trumps the will. Yep. Provided the beneficiary is alive. Yes, sir. Wa alaikum assalam. That's a good point. So I always say this, I'm not anti-will, I'm not anti-probate, I'm just pro-trust. And I say that because, again, in my personal experience, in my professional experience, probate court is not fun. It's not fun at all. It can take some time, right? Even when it's no conflict, the family's all in agreement and everybody's happy and, getting along. I've seen it still take a year. And generally speaking, people don't know how to go through that process by themselves, so they hire an attorney like me, and probate is not inexpensive. So, yeah, I'm gonna take your probate money for sure. And so, honestly, the fees I charge for our trust are less than the fees I charge for probate.
What's the average you do in trust? What's the ballpark as far as the cost?
Right. So our fees for trust started at $3,000. Our fees for probate started at $6,000. So, give or take. But I would say that probate varies, right? I've seen probate, the shortest probate I've ever done was 2 months. And that was just based on the circumstances. A mom passed away. She had one child. She owned one real estate property, free and clear. What I needed to file in probate was a different petition. It's a different thing I had to file than what normally has to be filed when somebody has a will and there's multiple people and there's multiple assets, right? Is nuances to it. I've seen probate I'm still in probate on a case now. It's going on 3 years because they had heirs property. That's another thing. And they're trying to figure out where's the property, the survey, and that takes time. During that time, one of the heirs has died. That's another wrinkle. Because now her estate has to have somebody appointed, right? I've seen probate take a long time because there's a minor child involved. Even if the heirs are the wife of the decedent and their child, that child has to have its own attorney. The court appoints that child their own attorney. That takes time. So it's always going to depend on the circumstances. And that's why I always say you have to take stock of your family dynamics. God forbid I pass away tomorrow. What does that look like based on what my family makeup is? What are my assets? How are they titled? Do I own it jointly with somebody? Do I own it jointly with rights of survivorship? Right? Is it just in my name? Do I have a beneficiary on this account or not? So really doing our due diligence and just answering those questions, that stuff you can do on your own you don't have to pay an attorney for that. Just sit and take the time and go through the exercise. And then, everything, it's titled this way. I have my beneficiaries in place. Well, what do I want to happen to my stuff? Going through that exercise. It's very freeing to do it. It's daunting to think about, but it's very freeing to do it. And once you get it done, that weight does kind of lift. So it's very important that we go through that process. Because again, if you don't, Georgia has a plan for your stuff. Yes, sister. Gotcha. So she had a question about whether there's a tax benefit, specifically on property versus a will versus a trust. So there's not a difference between the will and the trust for the property tax aspect. There's a difference if somebody gifts you a property, how the taxes play into that. But as far as if I got a property through a probate court process versus I got it through a trust, there's not a difference between the taxes as far as what taxes would have to be paid. And let me clarify that just a little bit. If you live in Georgia, at the person's passing, there's no estate tax. So Georgia, the state of Georgia, does not collect an estate tax from that person's assets. Georgia also does not collect estate inheritance tax. So when a beneficiary inherits an asset, they're not taxed for that, right? So you can inherit free and clear, and the estate is not taxed when somebody passes away. Now you can be taxed if you inherited real estate and then you sold it. Now you are taxed on the sale of that asset, but that tax you pay on the sale is different if I inherited it versus they gave it to me and then I sold it. There's a big difference in that tax threshold. It's important to know, again, Georgia does not have inheritance or estate tax. Uncle Sam does. But in order for Uncle Sam to take its 40%, your estate threshold has to be very, very high. Right now, that threshold for married couples is about 25 million, and for single people is about 13 million. I think Trump is extending that law to keep it like that. So right now, that threshold is high for the government to take 40%. Any other questions online? Okay.
Could you explain first fees for life insurance policies?
Right. So if you, that's interesting. That's on the life insurance policy. But per stirpes just means my descendants equally. Yeah. So if you have children and you say per stirpes, that means my children split equally. That's what essentially that's just it's Latin, legal Latin terms, but it just means between my descendants equally.
Yeah, I just saw it on my life insurance policy. I was looking at it.
That's your beneficiary. That's what it says.
It says I selected first fees, or maybe I should unselect it.
Um,
It's not supposed to be equally, right? For if I have sons and daughters.
we should talk to Zaima because I think you should think about a trust. And I mean, again, I think I'm not licensed to give specific direction about Islamic inheritance. I don't have that ijazah, right? My understanding of things, right? We have to look at the totality of the situation, right? And so I think that's important. Going back to family dynamics, what are those? We understand why, we're told men get twice. We understand why that concept is there. But I also think there's circumstances of why you consider that. You have to have that conversation, obviously, within your own family dynamics, because there are nuances and things that are within our family dynamics that only we're privy to. I won't go into detail, but yeah. Yes.
Someone has profit sharing where they work,
Yes.
and it's over a certain amount,
Okay.
and they already have a beneficiary for that beneficiary.
Hmm.
When they pass away, does that beneficiaries, are they still in charge of distributing profit sharing?
What give me more.
So,
You
so someone worked at a corporation.
Got it.
They no longer work there.
Yep.
But they made all of this money from profit sharing.
Yep.
So now they have children.
Yep.
And one child is the beneficiary, and that person is supposed to distribute the profit sharing.
Gotcha. Gotcha. So if it depends. Now they're not obligated to do that, because if they're the only beneficiary at the person's passing that obtained the profit sharing, that beneficiary will be distributed all of it. Then it will be upon them to distribute it if they decide to do that. The only way to guarantee that happens is if the profit sharing actually goes to a trust, and then the trust dictates how it goes out. So I always say that, like, we have a situation now, unfortunately, a client passed away, and we help clients fund their trust, and then we also give clients the ability to do it themselves, and it's the client's prerogative. He decided, I'm going to fund it myself, right? We did his real estate. He decided he's going to fund everything else. He did not fund everything else. Unfortunately, he passed, and his sister, and this is exactly what he told us, my sister's going to do the right thing. Okay. Unfortunately, he passed. His sister's the beneficiary on his life insurance policy. We had a meeting with the entire family. The entire family is pissed off at her. And she's just like, okay, y'all can be mad, but I'm the beneficiary. I don't have to give this to anybody. And so she's not doing it. And we can't force her to do it. We can only just, now we play therapist to the family. That's really all we can do. Yes, sister.
Are you saying that if you have more than one child, it's better to list all of them as beneficiaries?
Yes. If you have multiple children and you have retirement, life insurance, bank account, any type of account where you can name a beneficiary on, and you want to make sure that asset goes to the children in a certain percentage, you should either get a trust, and the trust is the beneficiary, and then the trust outlines the distribution shares, or you name each child as a beneficiary and their percentage is specified in their beneficiary designation. Because if you leave it just to one child, assuming and hoping that they're going to share with their siblings, it happens. I mean, you don't know, right? And again, we hope, and again, there are siblings who do share and who will share, but there are people who do not share. And so you don't want to put them, let me back up. It's on us to do the proper estate planning. So if we don't do that and there's family conflict, that's on us, right? So we do all we can do to prevent and avoid the family conflict. Not to say it won't happen, but do all you can do to prevent it from happening. If it still happens, may Allah, take care of it, right? But we need to do what we can do to prevent it from happening. And how we do that is either making sure it's divided the way you need it to be divided, doing a trust, making sure you have an estate plan, even if you decide to do a will, doing something, having a plan, one, because we're supposed to, we're obligated to have a plan, and then having that conversation with the family. Yes, sister. Mm-hmm. Yes. Mm-hmm. Your entire estate. Yes. So just for example, her question was going back to the Islamic inheritance guidelines and rules, where it says you can reserve a third of your estate for distribution to non-Muslim heirs or non-Muslim family members or to charities of your choice. That is a third of your entire estate. So let's say your estate is $3 million. A third is $1 million. Yep. Any other questions? Anything else online? Yeah, so when you include real property too, of course real property can't be divided into three, but let's say all you had is real estate and you wanted to leave a third. You could say it has to be sold and that's how it's divided. Or, hey, I can't leave this asset to you. I want to keep it in the family. And so what has to happen is now maybe the other sibling has to buy her interest out. So she still gets they still get their share. You might have to be creative in how you do that. Yes, sir.
What is the name of your law firm and what other Islamic law firm?
Yes, so the name of my law firm is the Law Office of India Wa Ali. A good friend of mine, colleague, attorney Mahdi Abdul Rahman is another attorney. He does have a JAZA, and he and I and our teams are in concert working together. He no longer does the estate planning piece. He's referring a lot of the people our way, but he does offer consultation to make sure that our clients understand the Islamic inheritance guidelines. So, Mahdi Abdul Rahman. Yep. Yep. Of course.
One more question. Is there a checklist with the due diligence questions? You mentioned that lay people can use as a guide to begin clarifying those items and putting our business in order before obtaining any trust.
Yes. The acronym FAITH, F-A-I-T-H, is your checklist. FAITH, F-A-I-T-H. That's your checklist. Family dynamics. What are those? Are you married? Are your parents still alive? Do you have young children? Do you have a non-traditional family where you're taking care of nieces and nephews, aunts and uncles? Do you have a blended family? Right? Do you have grandchildren you want to take care of? Really thinking about your family dynamics. Are you a brother with 2 wives, multiple wives? Thinking about that. Understanding your family dynamics. Your assets. Take stock of your assets. Assets and liabilities. So knowing what you have, who you owe. What are your instructions? What do you want to happen to your stuff? So if you're not Muslim, you want to make sure the family knows exactly what you want to happen to your stuff. They don't need to be second guessing or comparing conversations that they had with you at different times. They need to have clear cut instructions and a blueprint about what you want. Then taking all that into consideration, then you're going to make the informed decision based on my family dynamics, based on my assets, based on my instructions. What estate planning tool is going to carry out what I want to accomplish? Is a will going to do what I needed to do? Do I need a trust? Based on what I have, am I okay just with beneficiary designations and power attorney forms? So that's what you need to ask yourself. And then the H in faith, I'm not sure if I got to that, but the H in faith is just making sure you have help. If you have questions, seek out help. Don't go on social media seeking out help. Don't do that. Ask somebody that's an expert. Ask an estate planning attorney. All our consultations are free. All information is free. Right? We do 30-minute consultations. If you get me on the phone, you'll get maybe 40 minutes. If you get my husband Ishmael on the phone, you'll get an hour and a half of conversation and information. And so
When is he at work? What is his hours?
I would say he takes about 95% of the calls. I'm like, dude, you missing the next call? What you doing? But no, like we pride ourselves on just information is free. It's free. So any questions you have is free information. So I think if they follow the faith acronym, that's going to guide them the way they need to go, inshallah. And Sister Brenda, did you have a question? Wa alaikum assalam. Alhamdulillah.
One of the best, y'all. One of the best. If you don't have a trust, get it. Sign up today.
Inshallah. Alhamdulillah. Alhamdulillah. Any any other questions or comments? Did you have a question? Yes. It's okay. How old are you? Okay. You're older. I mean, you look young. Are you married? Any children? Any assets? But you have a bank account. You have life insurance? You should get life insurance. You should definitely get life insurance. Now, you definitely want power of attorney documents. For sure. Right. Is that your dad? You here by yourself? Okay. Now I say that to say, because God forbid you ever incapacitated, you will want somebody to be able to access your stuff and make sure any bills you have still get paid, right? But I don't think you need a trust. I do think you need power of attorney documents, and I do think you should get life insurance. Now, once you get life insurance, we could circle back on that trust conversation. Yeah, the beneficiaries on the accounts. Right. So that's where it's tough. That's where the trust comes into play. So you might need one actually. If you're saying the money I have in a bank, I want to make sure that it follows the Islamic inheritance laws. Having a trust and naming the beneficiary on those accounts, the trust, your trust can say these funds are to be distributed per the Islamic inheritance laws. We don't know the equation right now, right? We can say right now you're alive, and obviously if your mom and dad are alive, what the breakdown of your siblings, what the breakdown should be, but we won't know the exact breakdown until you were to pass away. That's when the equation kicks in, because now we can look at, well, who survived you? If you want to make sure it follows that, then maybe that is a potential conversation about a trust, just to be clear. Because if you did the breakdown now, and let's say you passed away and the person you named has passed away as well, you never changed it, then that is a probate situation now. For that, it's a potential probate situation. I always say it's important to talk to a rep at your financial institution, because you can ask them, well, if I split it up 5 different ways and one person passed, does it automatically go to the other people that I name, or will that 10% have to go through probate court? You will want to ask them that and clarify. You can say your will. You can just do an Islamic will that will actually break down. Yeah, Islamic wills already have all that in there. Right. So if you have a beneficiary named for an asset is not going to go through probate. And then remember, all wills go through probate court. Right. Yep. Thank you for that question. Okay. It's 4 o'clock. Okay. Well, alhamdulillah, I appreciate you all for coming out and listening to the information. I hope it was helpful and beneficial. May Allah bless us all and cover us as we exit. And inshallah, I'll see you all. Please schedule your free consultation call. Our fees for trust start at $3,000. Yes. I do my office is right there, so I can grab them and bring them back, inshallah. Do any of the brothers mind closing us out in dua? Right here. Yeah, you can do it, brother. Inshallah.
Close out with
Alhamdulillah. Thank you, brother.